Today we're here with attorney Stuart Greenberg, a graduate of the University of Miami Law School in 1979. Stuart received an AV rating from Martindale-Hubbell during his first year of eligibility in 1989 and has maintained that company's highest rating ever since. He has also been recognized by Who's Who in American Law, Millennium Edition, and appears in Martindale-Hubbell's Bar Register of Preeminent Attorneys. He has been in this edition since the year 2000 and has maintained that status ever since. Stuart runs one of the largest personal injury practices in the state of Florida, and today he's going to be discussing how to grow a successful personal injury practice and all the different components needed. Thanks a lot, Stuart, for being here.
You're welcome, Rick. Good morning.
So, Stuart, you've been in practice, it seems, forever. How did you decide what area you wanted to practice in, and can you share with us the different types of personal injury practices?
Once I committed to becoming a personal injury attorney, I realized that I needed to limit my practice to certain specific areas. And I decided to pick those areas where I felt I could best help my clients and their families to achieve their goals, which would be a successful resolution of their lawsuits and their cases. What I first decided to do was really look at the economics of the practice, which I think anybody beginning a practice needs to look at. People think of personal injury lawyers as being successful, as being people who handle 6- and 7-figure cases. That's nice, and my firm has handled many of those, but we also have handled 4- and 5-figure cases, which are as important to clients as the larger cases. So in beginning to look at a personal injury practice, you have to learn the basics of the law, the economics of a law practice, how you go about staffing your office, how to run your office, the software that's necessary, and the large investment both in personal time and finances which are required to have a successful practice.
Great. Well, let me ask you a question. There's obviously many different types of personal injury practices. Could you expound on some of the different fields that are out there available to attorneys, and also maybe a little bit more on how you picked your niche in personal injury?
Sure. Everybody knows about automobile crashes or automobile accidents. There are slip and fall cases, which are premises liability cases, product liability cases, medical and dental malpractice cases, cases involving cruise line injuries, areas involving prescriptions which are improperly filled, injuries to employees on the job for a workman's compensation setting, or injuries in cruise line employees for a Jones Act setting. These are just some of the areas of personal injury. Our firm has decided to practice in some of these areas, but not all of them, deciding that we wanted to focus and become knowledgeable on a few areas as opposed to trying to cover the whole gambit and not really understand the intricacies of the law, which are necessary in order to have a successful practice. I started out, and still do, primarily wrongful death, automobile crashes, premises liability, trucking, motorcycle crashes, and product liability and medical malpractice cases. I do those because, number one, I enjoy them, but number two, they all have some commonality. And that commonality is that they involve dealing with the public, dealing with physicians, medicine, and understanding the ramifications of what a person's injuries are, and also dealing with experts. And I want to talk about experts and doctors a little bit later in this discussion.
It's interesting that you say that you enjoy your cases. I know that you probably have seen a lot of people that do go into this field to practice for the wrong reasons and don't attain the outcomes that they would like. Could you expand on that a little bit?
Sure. There are many people who seem to be jack of all trades and masters of none. They may practice real estate law, bankruptcy law, commercial litigation, criminal law, personal injury, traffic tickets, things of that nature. And there are certain areas where it's appropriate for somebody to be a general practitioner. But I believe if you want to have a successful personal injury practice, and what I mean by success is not only making money for your clients and your firm, but getting good results. You really need to understand the law, you need to understand the intricacies, you need to understand the financial requirements, and need to understand how to play the game, if you so to speak, so that you're going to get the best results. I've handled many cases which other lawyers started working on in other firms. And I'll give you an example. I had a case come to me early in my practice where a couple were killed in an automobile crash. The family went to a lawyer, and he was trying to get them to take a $7,500 settlement offer from a major tire manufacturer. And we're talking in the early 80s, before tire cases were a big thing. When we got into the case, we created a whole database, learned that these light truck tires manufactured by this company had a defect in them which caused this accident, and we resolved the case for well over $1 million. After that, I went to this lawyer and said, look, you have gold in your cabinets. You've got cases that you don't understand the value of. You're settling them for cents on the dollar. And I'd be happy to look at them. I'd be happy to advise you on them at no obligation. If you wanted us to represent your clients, we'd pay you a nice referral fee. And his response was no. And what many lawyers do, unfortunately, is they try to make a case, settle it for a small amount of money to get their overhead going, but don't really do themselves or a client a service. They'd be doing a better service for themselves or a client if they realize that they don't have the financial means to handle the case, or if they don't have the expertise to handle the case. And what I want to do as part of the seminar is teach someone how to go from handling the smaller cases, handling them well, working themselves up to be able to handle the larger cases, the more complicated cases, the more expensive cases, to service both themselves and their clients.
So let's talk a little bit about preparing your firm for the different types of practice. Obviously, there's a number of different components when you're first starting your practice, or even if you're an attorney looking to refocus where you want to go with your practice career. Maybe you're a generalist and you want to get more involved in personal injury. So could you tell us, if we're starting from scratch, let's say, from square one, what are the most important components and how do you prepare your office?
One of the most important things is deciding upon how much you can afford to spend to run your practice. I believe you need to have in your pocket 6 to 12 months of overhead or access to overhead. And what I mean by that is you need to develop a banking relationship, get a line of credit so that when cash flow in our business does vary, you could go to the bank and borrow some money to help finance your cases. I'm a firm believer in what my father taught me. You need to spend money to make money. So you need to make sure that financially you have enough to live on, you have enough to pay your overhead, you have enough to pay your experts, you have enough to pay the costs involved in proceeding with a lawsuit. You also need a good staff. And the size of your staff really depends upon the size of your practice. But you need to get a staff that's going to be personable, that's going to be caring. You want a staff that's going to reflect your interest in the cases, people that aren't just there to make a paycheck, but are there to make a difference in the lives of the people that you service, your clients. So one of the things you want to look at is having a great receptionist, because the first contact anybody has with your law firm is going to be through the person who answers your phone. We're fortunate. We have a wonderful receptionist who greets people, makes them feel welcome, and makes sure that their calls get routed to the right person in our firm. You also need to have secretaries who understand not only how the law works, but also how you want to run your practice, how you want to service your clients, how you want to make sure that your clients are brought up to date, that they feel a part of the case, that people want to feel that the law firm that's representing them is interested in their well-being, their health, their financial crisis. One of the things you're going to learn in a personal injury practice is you have to be more than just a lawyer. You're dealing with people who are going through not only emotional and physical pain, but financial pain as well. Many times people who have personal injuries can't work, which creates a terrible financial strain on their families. You need to take the time, and your staff needs to take the time to try to work with these people to make them understand that there is light at the end of the tunnel. There may be other options you could point them to, companies or governmental agencies which could help them through their tough times. And all of that is important in maintaining good client relationships, which is the key to a successful practice.
Let's talk a little bit about the staff again. And you said some of the legal assistants. What type of experience do you look for in a receptionist, in some of your secretaries, or do you look for people that are fresh out so you could mold their experience?
That's a good question. I've done it both ways. The advantage of looking for someone fresh out to mold them is just that. You get to change them or train them into the way you do things. But there's a learning curve, and that learning curve sometimes is too long. So I think you need basically a combination of the two. You need some experienced personnel who could step right in, who know the court procedures, who understand how to handle, for example, if your state's a no-fault state, the filing of those claims. And you also want some people who you're going to be able to train in the way you want to do things. When I hire someone, I tell them I value their opinions. I value anything that they bring to the table. If they think there's a better way of doing something, please let us know. We'll certainly look into it. I try to include my staff as much as possible in our cases. I will call roundtable meetings a few times a week and bring in everybody and say, look, we have this case. I'll give them the basic facts, and I'll ask them what they think, because their opinion is probably better than mine. They're not as in touch with the case as I am. They're not as close to the case, but yet they're out there living in society. They're citizens just like the other citizens who are going to be judging this case if it goes to trial. And I want to know how they look upon things, how they view certain ideas, certain concepts, certain flaws that every client has, certain problems that every case has. So I make them feel part of the team, and we promote a team practice. But I look for people who are caring. I look for people who are diligent. I look for people who are responsible.
And where do you find some of these people?
Well, we advertise. We put ads in the paper. There's no secret to it. And we also ask the people that work for us if they know anybody else who's available. I will also tell you that when I am short a staff member and I'm talking to other lawyers' offices, I'll ask their secretaries or their paralegals or their attorneys if they know anyone looking for work. Because sometimes the recommendation is the best way to get somebody.
Well, let's talk a little bit about some contractor employees that you may need to retain, and also let's talk a little bit about your office space, the banking relationships you need to set up when handling a personal injury case.
The most important thing, I think, is immediately trying to develop a banking relationship. I've been fortunate. I've been dealing with the same group of bankers for 30 years. And I only deal with the president of the bank. We're on a first-name basis. We have lunch a few times a year. He understands my practice and my needs. If I'm having a year where my cash flow isn't as great as other years, but my caseload is terrific and I need to spend more money on cases, I'm able to call him on the phone and say, I need you to increase my line of credit. This is why, and I'll show him my cases, and he'll go along with me. It's nice to have that cushion, because you don't ever want to be in a position of not being able to properly invest in a case because you don't have the money. That's the worst feeling in the world. The defense will understand from day one whether or not you're meaning to go ahead and spend money on a case, or if you're just trying to get it settled. And I've always found that you need to spend the defense at least dollar for dollar to get the utmost value out of your case. If they see you're serious, if they see that you're not afraid to spend money, they're going to gain respect for you. And our business is a lot about respect, and it's a lot about reputation. So the bank helps you gain that respect and gain that reputation by going ahead and allowing you the ability to put money into your cases and work them up properly.
So you would then suggest that it's important for all attorneys to go and make sure that they go and meet their bankers and at least set up a meeting so they have an understanding of their business model.
Absolutely. Unless you're independently wealthy or are going to go ahead and fund every case yourself, you need to have a good banking relationship.
Now let's talk a little bit about office space. What type of office space layout do you need in order to have a practice?
You don't need to have big space, but you need to have a space that portrays a feeling of warmth and caring. That when somebody walks into your firm, they could tell by the way your furniture's laid out, the cleanliness of the office, the fact that there are individual spaces for the secretaries, paralegals, other attorneys in the office, that their privacy will be respected, their files will be protected, and that you have some semblance of success running through your firm. I can't tell you how many times I've driven up to meet someone at a hospital or a home, and they look at my car and say, well, you must be a good lawyer, you drive a nice car. It's not really true, but that's the perception people have. And your office and your receptionist is the first perception people have of your firm. So you want to make the best impression possible. And in doing your office, you really want to make sure that you have software and computer equipment that allows you to save time and save money by being as efficient as possible.
So let's talk about some of the software and the computer systems that you use.
Well, we use a case management system in our firm, which I really fell in love with and I enjoy using. And it's accessible to me from any computer anywhere in the world, which is very important when you're traveling on business or even when you're traveling on pleasure. I'm able to tie into my desktop from anywhere. I'm able to read my emails, my calendar. I'm able to see the scanned mail that's come in. I'm able to review notes on files, get all sorts of phone numbers, experts, review depositions, photographs, and things of that nature. And that every time we speak to somebody in a case, we send out an email, a letter. It all goes into this case management system. So we're basically paperless when it comes to a file. I don't need to keep asking the secretary to bring me such and such a file. I can find it on my own desk. It also helps, for example, if I'm talking to one of my clients, my partner's clients, who my partner may be out at a hearing, at a deposition, one of his clients is upset, I could pull up their case on my computer, pretty much understand from the case notes, which are kept on an ongoing basis, what's going on, and try to help that client through their situation, answer their questions as best as possible. The calendaring system is extremely important. As anybody who does personal injury knows, deadlines are critical. You commit malpractice if you miss a deadline. Not only statute of limitations, but responses to discovery, answers, and other things all have to be deadlined. And our calendaring system not only puts down the deadline, but we've set it up in such a way where there are warnings which pop up, reminding us that you have X amount of days until this happens, and a couple of other reminders along the way, so nothing comes up at the last second. You're not running around the last second, scrambling to get something done. You've got enough time to go ahead and get it done. Organization in a personal injury practice is the most important thing because it's money. And money is what it's about, and getting good results is what it's about. Without organization, you can't do either one.
What do you say to those attorneys out there that say, well, I can't afford that system, or I'm not, technology literate?
A few years ago, I knew nothing about technology. I will not tell you that I know a lot about it now. However, I have hired the right people and done the right research who put in my system and have taught me enough to hunt and peck and find what I need to find. As far as the money is concerned, there again, you've got one of two ways to finance it, either out of your pocket or go take out a separate loan from the bank and pay it back over time. But it's invaluable. And it will also save you staff members because the productivity of the staff that you have is doubled or tripled because of the technology that's available today.
For those attorneys who still say, well, I can't afford it, or it doesn't make sense to me just yet, can you give us an example of where this system really saved a case or helped to kind of get your staff focused and get everybody on the same page?
What we do in our firm is we have case reviews where we basically go through every case in the office. We put it up on a big screen. We sit there with the attorney, paralegal, secretary, and we are able to pull up everything on that file that we need within a few moments and create what's called a case plan. And that case plan directs everyone what to do. And the nice thing about that, Rick, is accountability. I can't tell you in the past how many times my recollection is I've asked somebody to do something, it doesn't get done, and a judge comes back and yells at me, or I miss a date or something of that nature. With this system, there's complete accountability because everything is documented, everything is logged in, And as a result, you don't get yourself in trouble. You don't miss dates. Things fall into place in a natural and orderly fashion, which is great when you're a trial lawyer, because that's the way you want to be. You want to be organized.
So having a computer system is definitely a must-have in your book.
Yes, it is. Unless you're handling a few cases or small cases, and that's great. I mean, if you want to start out handling a few cases and small cases, I think it's terrific. But if you want to grow your practice, you're going to have to grow it. And let's talk about growing a practice for a second. Not everybody can start out handling big cases because they take a lot of experience, they take a lot of money. You could start out possibly handling a small case, an automobile case. If you do all the research, you understand the law, you don't need to put that much money into it. And if you want to grow your practice, associate yourself with one or two firms who practice in the areas that you want to grow into, that will allow you to co-counsel cases with them, that will allow you to learn from their procedures, their practices, the way they take depositions, the way they do discovery, the way they analyze cases. And by doing that, when you make your referral fee, you're going to be able to grow your war chest a little bit, so that you're going to be able to handle larger cases. I didn't start out handling large cases. I started handling small cases. But over time, as I developed more of an area of expertise, I developed more cash. I was able to expand my practice to where now I'm lucky enough to be able to work with other firms who can't afford to do those things, bring those young practitioners along, help them out, give them cash flow, and at the same time watch them grow into successful trial lawyers. And that's a lot of fun.
So would you recommend for some new attorneys, maybe not the veterans out there who are listening to the program today, that they should associate with a veteran trial attorney and maybe do some sort of internship or an independent contractor agreement with them if they want to get involved in personal injury?
Well, I think they should do more of a co-counsel type agreement. You know, there are referral lawyers we all know about, and referral lawyers make fees, and if all you want to do is refer cases and make fees, I think that's great. I think you're doing your client a service because you're saying to your client, you know what, there's somebody with more experience that can handle your case and get you a better result, and I'm going to step back and just make my percentage. And at the same time, you could say to your client, you know, this is a case I want to be involved in and work with, but there's another law firm that I think I would work well with together. It doesn't cost you any more money. You're paying the same contingent fee, but you're going to get a better result. And in doing that, you're going to learn how to handle these cases and make some money. So I think it works both ways. You really have to decide what it is that you as a practitioner want to accomplish. And I respect people who do both.
Great. Well, tell us about some of the forms that are necessary that you're going to need in order to operate this practice.
As a personal injury attorney doing plaintiff's work, there are certain documents which reoccur. It's not as common as a defense practice where almost everything is forms, but there are a lot of things which you could use over and over again. For example, there are automobile complaints, which are basically form complaints. We have those set up in different categories. If it's a single plaintiff, if it's a husband and wife plaintiff, if there is a single defendant, if it's a multiple defendant case. We have those forms, so basically all you've got to do is tweak certain things. You have to tweak the names, the dates, the locations of the accident, the facts of the accidents, but pretty much the complaint is there for you. So a good paralegal or even good legal assistant could go ahead and make those modifications and changes, and you as a lawyer don't have to sit there and dictate a 3 or 4 or 5 page complaint over and over again. Interrogatories forms are important, and we have standard interrogatories for automobile accidents, trucking accidents, motorcycle accidents, medical malpractice cases, surveillance interrogatories, expert witness interrogatories, things of that nature, so that all we need to do is say we need a set of interrogatories in the Smith case, we need them sent to these defendants, and the paralegal will press the button and they'll come out. Same as requests for production. Yes, everyone needs to be tweaked somewhat, but as long as you've got the initial forms, it helps a lot. There's also letters to medical providers requesting medical records, bills. We send out quarterly letters to every client asking them what medical attention they've had during those few months in case they haven't brought us up to date so we could get those records. We send out requests for employment records. A lot of these are forms which, if you had to start them and type them from scratch, would be time consuming. If they're in your machine, if they're in your practice, you push a button, it comes out much easier.
And how did you originally get these forms, these interrogatory forms and all these? Did you design them yourself? Did you gather them over time? Is there a place where you went to which had some form templates?
Well, it's a combination of all those. Over time, we've certainly created them. Some of the states have books where there are acceptable forms in them. Some have required form sets of interrogatories which must go out. But the whole idea is organizing these forms and letting your staff know when these forms are to be used and making sure that the forms meet the current bar requirements in your jurisdiction.
Great. And tell us about some retainers. And you'd mentioned contingency fees, you mentioned co-counseling with people, referral fees. Tell us about some of the retainers that are necessary in order to run this practice. Obviously, cash flow is very important, and you can't always take on cases gratis.
No, we don't do that. We certainly do our share of pro bono work. But let's face it, you can't help a client unless you have the cash flow to spend money on their cases, pay your staff, and pay your vendors. Most states have contingency fee agreements, which are standard. The fees are set forth, the percentages, who gets paid what first, whether it's costs, whether it's fees, whether it's outstanding medical liens, etc. Some states also have client statement of rights, which explain to clients in simple English what their rights are as a client, which is very important. And we make sure that not only we go over those forms with the clients when they retain us, but we also give them signed copies of those forms so they have them for their records. Recently we created another form which is basically a receipt signed by the client stating that they have received this documentation from us. They fill out HIPAA or medical authorization so we can get all their medical records. And I want to talk about the importance of that in a few minutes. We also send out standard letters after we are retained in a case, thanking the client for retaining us, telling them how much the confidence that they have in us means to us, and that we're working this case together. We're a team, and we ask the client to let us know what is going on in their lives, both with regard to the case we're representing them on and to other things. I don't want to be surprised. What I'll tell every client is, you've got to tell me everything, both in the past and the future, because if I know what's going on, I could help you. We could figure out how to deal with things. Everybody has things going on in their lives which are normal, but unfortunately in a lawsuit may come out. If I know about it, I could advise the client, I could handle it. If we're surprised, it's going to be a disaster. And the last thing you want in a lawsuit is a surprise.
Well, tell us a little bit about what makes your decision to retain a client, because obviously you're not going to take on every case that comes through the door.
The most important thing in a personal injury case, and the hardest thing in a personal injury case, is deciding which cases to take and which not to take. Because you don't want to turn away a case that's going to produce cash, and at the same time you don't want to take a case that's going to drain your firm of time and dollars when your chances of winning that case are small. I view personal injury lawyers as gamblers. The only difference is we're not gambling on a blackjack card, a roll of the dice, a horse in a race. We're gambling on ourselves. And I'd much rather gamble on me than anyone else in the world. But at the same time, I have to be a smart gambler because I'm investing my time and my money. So when I look at a case, I've got to analyze it and see what percentage of time do I think I'm going to win this case. And this is the first time I hear about the case. I've got to make these decisions instantaneously. And then how much is the value of the case? Now you're not going to know from the first time exactly what a case is worth, because a simple automobile accident may turn out to be a herniated disc, which is worth a lot more money, or something more complicated. But you've got to develop a gut feel. It's hard at first to look someone in the eye and say, I'm really sorry for your pain, I'm sorry for what you've been through, but I don't think my firm can help you. But you need to do that in order to have a successful practice. You need to say, I understand that you're injured. I understand that you're angry that the person who caused this accident changed your life, but there is no insurance coverage, or there's very minimal insurance coverage, and your medical bills and expenses are going to go to pay back the health care provider for their lien, or the government for their Medicare or Medicaid treatment. You're going to wind up with nothing, and therefore I don't want to make you unhappy at the end of the case. So I'm going to bow out of it. It's hard to do that, but it's the right way to do it. And you are going to wind up with some cases that you're going to be sorry you took, and you're going to have to deal with those cases, sometimes withdrawing later on in the case, other times carrying them through to the end and saying to your client, look, this is the offer, I'm reducing my fee, I'm not going to take a fee, I'm sorry, but this is all it's worth. And that's how you develop client relationships as well. People want to know the truth, they don't want to be lied to. And if you tell them the truth, as soon as you know it, the better off you are.
And I'm sure you get a lot of people walking through the door that think they have that $1 million case and really don't.
That happens all the time. And the first thing I'll tell a client is, you don't want the $1 million case. Because in order to get $1 million, you have to have sustained a very significant injury. This is not the hot coffee cup in McDonald's situation. And I hear about that all the time from jurors. Most 99% of the cases settle, or juries bring back, I think, fair and just results. There are those times where juries get overboard and either find against someone and give them nothing when they should have, or give them a ridiculous amount of money when they shouldn't have. That's the exception, not the rule. But you've got to be able to look someone in the eye and tell them, I'm very sorry, I can't help you.
Well, let's talk a little bit about some of the authorizations. We talked about the retainers and talking to the clients about that. Let's talk about some of the authorizations that you had mentioned before.
What we do in our firm is we have them sign medical authorizations right up front. We get the medical records from every healthcare provider in every hospital, every clinic that we know they've ever been to in their entire life, because you never know what's in those records, and to be honest with you, clients don't always remember what's in those records. People don't remember sometimes even being to a doctor or a hospital 5, 6, 10 years before. And I don't think they're lying, I just think that's the way human nature is, you don't remember. And we keep trying to remind them throughout the case, and at times they'll say, you know what, now you've made me remember this, you've made me remember that. You need to spend the money to get those records, to review them, to see exactly what's in there, and I'll tell you why. Let's say somebody comes in complaining of neck pain from an automobile accident, and I'll ask them, and I have a whole list of questions that I ask them. Ever had any prior neck complaints? Seen a chiropractor, seen a neurologist for any reason, seen an orthopedist, emergency room, been hospitalized, were you on any medication? A whole list of questions. They'll say, well, I saw a doctor 6 years ago, but it wasn't for my neck, or I'll get those records, and sometimes you'll be surprised that it may say, complained of stiff neck. And that doesn't bother me per se, because that may be the only reference in their history to a stiff neck. But I want them to go tell their treating physician now, from the accident, you know, I did go to my doctor 6 years ago, I had a stiff neck once, it was nothing. And that all goes to credibility, because the treating doctor wants to know the whole history. You as the lawyer want to know the whole history. And if the client is honest and patient is honest in telling the whole history, that can be dealt with. The worst thing that could happen is you don't want a doctor sitting at deposition and having the defense come up and say, well, doctor, did you know that your patient complained of neck pain with pain radiating into their arm 6 years ago? And the doctor looks bewildered and says, no. Well, would that make a difference, doctor, in your opinion today? And the doctor, again, having based his report on the fact that the client had no pre-existing history, is hard-pressed to say, well, it could make a difference. So you want the doctor to be prepared. You want yourself to be prepared. You want the client to be prepared. And the only way to do that is to get those records, review them, and be careful about them.
So now you've got the retainer taken care of, you've got the authorization signed. Let's talk about some of the initial letters that you send out to open up the claims and to the clients itself.
One of the first things you need to do is put the insurance carriers on notice. And the reason you want to do that is, number one, you need to get the coverage information, if your state permits them to give it to you, as to how much coverage there is and what types. So you could start understanding what is available to your client, whether it be through bodily injury coverage, uninsured motorist coverage, premises liability coverage, professional liability coverage, etc. You also want to start preparing the adjuster from day one about the value of your claim. And that's important because adjusters have a job to do. Their job is to represent the insurance carrier. Their job is to assess their claims, and their job is to set reserves. And many people don't understand that setting reserves in a case is critical, because once an adjuster and his supervisor put a number or a range on a case, it's hard to get them to change that upward. For example, if they think a case has a value of $50,000 to $75,000, and a year or a year and a half down the road, you're making a demand for $1 million because your client's got a closed head injury, got a cervical injury which resulted in surgery, you're making it more difficult for you to get that kind of money because the insurance company hasn't evaluated the case that high. What we do is we, on an interim basis, send out letters to the adjusters and speak to them and let them know exactly what's going on to reserve their cases properly. Because I don't want to have the problem later on where an adjuster is between a rock and a hard place. I don't consider an adjuster my enemy. I consider him a professional who I have to deal with in this case and cases in the future, and I want to develop a good relationship with him. I want to make his job or her job easier for them, and I'll tell them that. And I tell them that I'm willing to share information and hopefully work towards getting this case resolved between the two of us. Not just in pre-suit, but also during suit. There are many cases we'll get that we'll file right away because we just know the insurance company won't pay the types of dollars we're looking at voluntarily without doing some sort of discovery. And we're very open in discovery. We will turn over everything. And we'll do so because we want the other side to know that we're not afraid. We want the other side to know that this is our case and we're going to stand by it and we're going to fight it.
So obviously it's very important for you to form that relationship with the claims adjuster and the people on the other side. So let's talk a little bit about your reputation then. Obviously you can choose to be either a negotiator or a litigator, or maybe both. What are your different options? What are the pluses of one reputation, so to speak, as a negotiator versus the minuses, and the same as for a litigator?
I don't think they're mutually exclusive. I think the reputation has to be more of, are you someone who's willing to spend the time and effort to prosecute a claim and do it properly, or are you one that will never go to court, will never spend the money on a case that's required, and will just get the highest offer you can from the insurance company and run? And there's a big distinction between the two of those. I think the reputation most of us want is the one that the insurance companies, when they see our name come across their desk, are going to say, wow, they know what they're doing, they're in this for the long haul, they're going to work up the case from day one as if it's going to be tried, we need to take them seriously, and we need to be fair in this case. No insurance company is going to overpay you. All you really hope for in a settlement is to get fair value for a case. And that's your goal. And there's a lot of ways to go about doing that. So let's talk about that for a second. We spoke before about the importance of talking to the adjusters right away and developing a rapport. One of the other things you need to do is develop a rapport with your client's treating physicians. Now, if you practice in the same community for years, you may know some of the doctors. That's great. Sometimes you may not know some of the doctors. And I have a philosophy, basically it's the 3-visit philosophy. If there's a new doctor on a case that I don't know, I'll make an appointment, pay him for his time, go out and speak to him and introduce myself. I'm Stuart Greenberg. I represent your patient, Joe Smith. I've never met you before, doctor. Here's a copy of my firm brochure, my card. I want you to understand that I'm here just as you are to do what's right for my client, your patient, with regard to what happened to he or she in this case. I don't want you to do anything or say anything that you're not comfortable with, that you're not sure of, but I want to talk to you about their injury, and I want to talk to you about their prognosis. So you're trying to develop with the doctor a sense that you're fair, that you care about the patient, and that you want to understand what's going to happen. And that's important because you need to tell the doctor, look, our client has one chance, he has one opportunity. Once this case gets resolved either by settlement or by verdict, they can't come back and say to a jury, you know what, I needed more care and treatment, you didn't give me enough money. So doctor, you and I together have to figure out what's going to happen to this client down the road. For example, I met with a doctor the other day, and we discussed a fracture in a joint. And I said, doctor, are there going to be arthritic changes as a result? He says, well, you know, when you fracture and the fracture extends into a joint, chances are there will be arthritis. I said, well, this is a young person. Tell me what will happen if this person develops arthritis? Well, they're going to be in pain. They may need to have this operation. If that doesn't work, they need to have that operation. I said, well, doctor, I understand that. Are you comfortable in saying that within a reasonable degree of medical probability? And I try to work it up so I understand exactly what the client will go through. It's maximizing my client's damages. It's anticipating my client's damages. And I want to get the doctor thinking along those lines. And I won't do it heavy the first meeting. I'll do it very light. I'll come back for a second meeting. And in the second meeting, the doctor's had a chance to spend more time with the patient, do more studies, see how the patient's reacting. And I'll delve into it with him a little bit further and talk to him about, well, he's got a knee injury. Is it going to affect his gait? Is the gait going to bother his hip? Is it going to affect his back? How does it affect his activities of daily living? And throughout this time, I've met with my client or spoken with my client, and I've told him, look, you're going to go in and see the doctor. He's going to say, how are you doing? And patients, like everybody else, want to say, I'm doing better. I said, doctors like to write down patient doing better. I said, that's great, but it's not what you want to see in a medical record that you're going to be cross-examined about. I said, well, I don't want you to lie. I want you to tell the truth. But you're not doing better because you're not doing the same. You're doing better, but you're not the same you were the day before the crash. I said, that's the gold standard. How are you feeling the day before you were injured? So when the doctor says, how are you doing, tell the doctors what pains you have, what limitations you have, what frustrations you have. Hopefully they'll write some of it or all of it down. But at least that way it'll be documented. I said, I don't want you to lie. I don't want you to exaggerate. But you need to tell the doctor what's going on from the top of your head to the bottom of your toes, even if you don't think it's related, because let the doctor figure out if it's related. Oftentimes people have injured parts of their bodies in accidents. They don't realize that they hurt. Or they don't realize that a pain in their leg is connected to an injury in their back. Let the doctor do that. And by the time I go back and see the doctor the third time, hopefully he's regurgitating a little bit of the things we've talked about. He's focused more on what's going to happen in the future to this patient and has helped the patient and me understand what the prognosis is, which only increases the value of the case.
So what you're saying really is that when you're working up a case or even just taking on a case, one, your reputation precedes you and will have an effect on how the other side might proceed. So it's important to be consistent and really be focused on the benefits of the client, the benefits and outcome of the case before you get involved in it, and make sure that your systems are in place.
Absolutely. My friends on the insurance side tell me the first thing an insurance company does when they get a claim letter is they look up the law firm. And they have notes and they know if a law firm is going to litigate a case, going to spend the money, what their successes are, what their failures are, and who the lawyers are. So that's critical, because that's dollars in your pocket and dollars in your client's pocket. And if you have the good reputation, that goes a long way in getting your case resolved and settled.
So what do you do as maybe a new practitioner who's just venturing into this arena of personal injury to establish your reputation, or even to introduce yourself to some of the claims people?
What you do is, number one, is you be upfront and honest. If you don't know the answer to a question, say you don't know, I'm going to find out for you. I've had adjusters call me up and say, well, tell me, has your client been involved in an accident before? And even though I've asked that question of my client, I'll oftentimes say, I'm going to check. And what we'll do is sometimes we'll even do a search. We subscribe to a search system that for $16, $19, and forgot what it costs right now, basically gives us a whole history of our client. Just like the insurance companies run histories. They have access to much more sophisticated computer systems than we do about claims and accidents and medical records. But we'll check out our clients, because we don't want to portray them in any other light other than being honest. We'll tell the insurance company the good points and bad points of our case. In our demand packages, we'll put in there that our client was treated 6 years ago for a neck problem one time, and he has been asymptomatic since and has nothing to do with this accident. I believe in being more upfront, because if you're upfront, they're going to trust you, they're going to believe you when you tell them, hey, he's really bad now, he's going to need this surgery in the future, he can't do this and he can't do that.
So that goes right straight to the heart of ethics when you're dealing in personal injury, and how being on the positive side is really going to help your client and your case.
Absolutely. People have horrible opinions of personal injury attorneys, the ambulance chasers, the people who make statements about how they just want to get money for their clients no matter what. You've got to be careful about that. I don't think you want to be that person with that reputation. And in that line, I just thought of something that I wanted to bring up now. Websites. More and more firms have websites. Adjusters are smart, juries are smart, defense lawyers are smart. They'll look at your website. They want to see how you present yourself and your firm. And you want to make sure that your website is dignified, that you present yourself well, and that you care about your clients and your website, that you're not in it for the money, that you're in it to do what's right, and you're in it for justice. And that goes a long way in helping your clients and helping yourself.
And obviously those attorneys who don't understand that are going to have it kind of bite them right in the butt, because the insurance companies will use their website almost against them in some instances.
Sure, and it's the same as with clients. When I interview a client these days, I say to them, do you have Facebook? Do you have MySpace? I say, get it down. Because with the sophistication of everyone out there, you don't want pictures of your client and information about your client out there for the general public to look at, for the insurance companies to look at, for the defense lawyers to look at, for the juries to look at. So you really have to be careful with all the information out there today, how to make sure that it's positive, not negative.
In fact, there have been a number of cases in the news just recently with clients that were on MySpace accounts or Facebook where it really ruined the case for them.
Absolutely. You hear about it happening all the time, and it's going to be more and more prevalent. And we've even instituted a system now where we bring our computer into the courtroom with us. In some cases have our jury consultant with us, and we'll talk about that at another time in another lecture. But we'll do research on the jurors or the prospective jurors and learn about them. And you learn a lot about people by looking at their MySpace or Facebook pages or things of that nature.
Can you briefly touch on how you lay out to your clients what to expect? Because I know once you retain them, once you kind of line all your ducks in a row before you start to proceed with the real work of the case, that client wants to know what to expect. So how do you handle that?
First thing we do is we tell them what we do for them. We tell them how we investigate their case, both from the standpoint of liability and damages. We look at their history, and we talk to witnesses. We gather experts, and we try to put together a whole concept or a scheme of how we're going to present their case. Do we need to hire an accident reconstruction expert? Do we need to hire a metallurgist? Do we need to hire someone who's going to discuss what the weather was at a particular time at a particular location? Do we need a vocational rehabilitation expert? Do we need an economist? Are they seeing the right doctors? And I find that more and more prevalent in my practice than ever before because of managed care. That it's hard sometimes for people to get a primary care physician to go ahead and refer them to a specialist when they really should be seen by a specialist. Or if you're in a no-fault state, have they seen the proper doctors? Do they need a neurologist? Do they need a spinal surgeon? Do they need a hand surgeon? They need a doctor who specializes in sports medicine for knees or hips or elbows or shoulders. We try to make sure that they're seeing doctors who can assess them. Because today, when you're going to see a doctor, and let's say he's an orthopedist and you have knee pain, and you tell him, you know what, I'm also having headaches, he may jot down you have a headache, but he's not going to treat you for it. So you want to make sure that you're managing their health care as well as their case. And that's a complicated thing that you've got to stay on top of. Because you don't want to let an area of injury go by because it may be significant to the patient, both from a physical standpoint and also from a monetary standpoint if you miss an injury.
Great. Okay, let's talk a little bit more about now. You've got that patient, you've told them what to expect from that, so to speak, putting the game plan together. Sometimes clients just don't hear what you're saying, especially if they're in pain, and all they hear is, yeah, you're the guy that can help them with their case. Do you deliver them any form of written documentation kind of outlining what they can expect, and what's your thought process on that?
It's very important. Communication is key. Lawyers get in trouble when they don't communicate with their clients, and clients don't understand.
The number one ethics complaint.
Number one. The first thing we do is we send out a 3-page letter after we sign them up, explaining to them a little bit about what you just said. That it's going to take time. This is what we're going to do. This is what you need to do. We send out a monthly e-newsletter to our clients about general areas of the law, but also reminding them to call us if they have any questions. We are diligent in returning phone calls. The biggest ethics complaint is, I call my lawyer, he doesn't call me back. Well, if I'm in trial, my secretary will call you back. If I'm with a client, my receptionist will say, he's with a client, he'll get back to you. If I'm out of town, they'll get a call from someone trying to help them or at least explaining why I'm not back on the phone with them at that moment. It's critical. We have a 24-hour, 7-day-a-week answering service, live answering service, that could get a hold of any of the lawyers or paralegals in the office. And oftentimes, we'll talk to clients nights and weekends just to allay their fears. I've given out my cell phone number and my home number because you're dealing with people who, to them, it's the most important case in the world. And you've got to treat that case, even though you may have 100 or 200 cases, as if it's the most important case in the world, because to that particular client it is. You need to go ahead and explain the process to the clients as often as possible. And sometimes to their family members. And we're very careful about that. If one of my clients has their nephew call and say, I'm Mary's nephew, I'd like to talk to you about her case, I'll say, I would love to discuss her case with you, but please understand from an ethical standpoint, without written permission from your aunt, I can't. So if your aunt gives me written permission, I'd be happy to talk to you. And clients appreciate that, and so do their relatives. They appreciate the fact that you're keeping their case confidential, and they'll thank you for it. And you'll get a letter from Aunt Mary saying you could talk to my nephew. And that's fine, because you want to have that understanding. You want to have that meeting. But at the same time, be careful, because if you have a meeting with Aunt Mary and one of her nephews or nieces or someone who's not a party to the case, you don't want to discuss certain attorney-client privilege things, because you may be waiving attorney-client privilege because you're talking outside the presence of just you and the client. So there's a fine line that you have to draw and be careful of as a lawyer. You don't want the nephew at a deposition to say, well, have you ever met with Mr. Greenberg and your aunt? And he's going to say yes. They're going to say, well, tell me what you discussed. You don't have a right to attorney-client privilege at that point. So be careful about that. It's a trap that you could fall into.
Great.
The CLE code for this disc is PIE 5926. This program continues on the next disc.